Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know, you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. We're back. Sorry I'm late. You know how much I hate being late, but I didn't have enough time to get ready in between the last show and this one, and I had to pull up a whole bunch of stuff, and I still am not ready. I'm not ready, but I have the papers. It's really devastating news for the Kowalski family, and we're going to read the whole entire decision. It's about 40-something pages, so you might want to get yourself a drink and settle in, get cozy, take off your shoes. Many of you may not have seen me since we last covered the Maya Kowalski case, which I had to go back and look. It was all the way back in 2023. It was right after I started my own YouTube channel. I started my channel in July of 2023, and this was, I think, one of the first cases that we covered together. All the way back in 2023. And as you may recall, the verdict in the Maya Kowalski case was over $260 million. So sad. You may have seen a documentary called Take Care of Maya, and I don't remember exactly what platform that was on. That's how many people became first interested in the case. But I'm going back to look at my playlist on this, which I think I've linked below. If I haven't, I will. And we didn't do gavel to gavel coverage on this, but we did recap a lot of it and a lot of the testimony. Let's see, what the verdict stream that I did was on November 9th of 2023. So it's been almost 2 years since the verdict. What a tragic case. So for those of you, the case was very tough to watch. Very tough to watch. And Recovery Addict, right, he covered it gavel to gavel. He was amazing. That's when I first met Scott over at Recovery Addict and so many other people in the YouTube community during the coverage of that case, because so many different kinds of YouTubers were covering it. And so many people in the chat shared their stories of living with CRPS. And it's a very, very, very sad story. I'm just trying to pull up this article here that doesn't want to flip over to the other screen, but of course, because nothing's working today the way it should. I'll move it over here. So for those of you who are not familiar with the story of Maya Kowalski and her mom, Beata, let me just do a brief recap for those of you who are not familiar with it. At the time this verdict came down, it was something like over $260 million. And you can correct me if I'm wrong, but I think it may have been the largest jury verdict in Florida. when it was rendered. And then there was a whole bunch of shenanigans, remember, with the jury and how they called juror number 1 and his wife back into court, and they wanted to obtain, the defendant hospital wanted to obtain the text messages of juror number 1 and his wife, because his wife was in some chats. It was crazy. It was crazy. I can't believe it was 2 years ago. So the story of Maya really goes back to the fall of 2016. And this is from an article that was published in The Cut in October of 2022. In the fall of 2016, Maya Kowalski was a 10-year-old girl who reported or was brought to the emergency room at Johns Hopkins All Children's Hospital in St. Petersburg, Florida. She was 10. Dr. Sally Smith was the medical director of the child protection team for Pinellas County, Florida. And she received a call from the emergency room that a child named Maya Kowalski had just been admitted for abdominal pain. Sally Smith was told that Maya Kowalski's parents, Beata and Jack Kowalski, had told the hospital that Maya suffered from a neurological disorder called complex regional pain syndrome, or CRPS. She'd also been undergoing K treatments. We have to say K. We are not allowed to say the word. I'm going to say it once. Ketamine. Please don't write it in the chat. Her parents had been taking her for this special kind of therapy because it was the only thing that was helpful to Maya and her debilitating pain. What happened was Dr. Sally Smith thought that Beata Kowalski had Munchausen by proxy, and somehow Maya was taken into state custody. I don't remember all the details. I'm trying to look through my notes real quick. And Maya's mother, Beata, was not allowed to have any further contact with Maya while she was in the hospital. YouTube is unhinged. I know. They don't like you to type it. They don't like you to say it. I did a whole stream on Matthew Perry and his death and talking about recovery, and they totally struck it because they didn't like what I said. And it wasn't like I was promoting it. I was just talking about it. So Sally Smith began to develop this theory that Maya Kowalski was a victim of Munchausen by proxy. And on October 10th of 2016, 2 days after Smith had been called, the Kowalskis told an attending physician that they wanted Maya discharged. And they were told if they left the hospital, it would be AMA, against medical advice. And they were told, the parents, that if they tried to take Maya home, they would be arrested. Sally Smith was evil, in my opinion. So eventually, Maya, based on the word of this Sally Smith, was taken into state custody. Her mother was forbidden to see her in the hospital. And then Beata Kowalski took her own life, because in Beata's mind, that was the only way that the state was going to release her daughter from custody. And so years later, the Kowalski family sued the hospital and Sally Smith and others on behalf of not only Maya, but the estate of Beata Kowalski, saying that what the hospital did and what Sally Smith did and what other defendants did caused emotional distress, wrongful death of Beata Kowalski. And then there was a trial, and we watched the trial together. And the jury came back with a verdict in excess of $261 million. This case has been up on appeal. There's been a lot of drama surrounding it that I have not covered, admittedly. Greg Anderson at the time was one of the attorneys. And I don't know what happened with Greg Anderson, if he was substituted in by Nick Whitney, because eventually they broke up, right? Greg Anderson and Nick Whitney. And so there was some stuff going on there with the attorneys. And so the highest court in Florida has heard this appeal, and they have basically thrown out the verdict, thrown out the lawsuit, dismissed a couple of causes of action, and they're sending it back for a new trial, but only on some of the causes of action. They're outright dismissing some other ones, which we'll get into as we read through it. Him and Whitney fought about some money issues. Yeah, something like that, right? The lawyers are suing each other. Thank you. And so the family has never collected a dime, right? Because all of the money, maybe they had to post a bond or something, the hospital. And it's been stayed while this appeal has been pending. Thank you, Keith. Keep up the good work, says Keith. Watching you from Chicago, Illinois. I love listening and watching you. He says that on he leaves that comment on every single one of my live streams, and you're so sweet. And thank you so much. And then there was a whole thing that happened with the jury. And there were some allegations against juror number 1. And they brought juror number 1 back into court and put him under oath. And he was a rock star. And they tried to get his wife in trouble too, because she was in some chats, some live stream chats, apparently super chatting people. It was wild. And you remember Dr. Joe Corcoran? We brought him on the show after. He was an amazing expert witness for the plaintiffs. He did it for free. And Dr. Joe recently sent me some information on juror number 1, which I wanted to share with you because he asked to share it with you guys, and that hopefully you guys could put some prayers up for juror number 1. Because recently, and many of you actually did write emails to Joe Corcoran, to Dr. Joe, and I thank you for that. He said, Dr. Corcoran, Dr. Joe told us that juror number 1 from the Maya trial had a massive heart attack. He needs to have open heart surgery and has been dealing with a series of significant complications. He was transferred for the 3rd time. His wife's name was Yoli. You might remember her as Hippo Lover. That's what she went by in the chats on YouTube. And many of you sent, after I told you that the first time, many of you sent Dr. Joe supportive emails, and I thank you for that because you are always so very kind and generous with your time, your money, and your empathy. And so I'm not sure of his current status, juror number 1, but please put some prayers up for juror number 1 and his wife. We're going through a lot right now. And sorry to be the bearer of bad news, but that's where we start. Medical kidnapping is a thing. And what happened in this case is horrific. And that's where some of our outrage on this channel began, was with the Maya Kowalski case and what was happening to Maya and what happened to Beata. It's horrible. And this ruling just came down, I don't know, yesterday, today? October 29th, 2025. That is today, October 29th, 2025. From the District Court of Appeal of Florida, 2nd District. I know you're desperate for their reasoning, so I will get started. Johns Hopkins All Children's Hospital, Inc. is the appellant here. They're the ones who took this up. Versus Maya Kowalski and Jack Kowalski individually and as personal representatives of the state of Beata Kowalski, deceased, dated today, October 29th, 2025. And this is an appeal from the Circuit Court for Sarasota County. Judge Hunter Carroll. Wow, he was such a great judge, wasn't he? You guys remember Judge Carroll? He was great. We love Judge Carroll so much. He was fair. He was honest. He got it. Hold on. And this was a civil lawsuit, and he presided over this with integrity, grace, and I really liked him a lot. And you'll note here that there were a couple of amicus curiae briefs filed by a couple of organizations, and they step in on these appellate cases when they have a special interest in them. And so there was one brief filed by the American Academy of Pediatrics and the Children's Hospital Association. And there was a second amicus curiae brief filed by the Florida Hospital Association. Judge Black is the judge who wrote this opinion. Johns Hopkins All Children's Hospital, Inc., JHACH is what we call them and what they're going to call them throughout the course of this decision, appeals from the final judgment rendered against it and in favor of Maya Kowalski, Jack Kowalski, and the estate of Beata Kowalski, collectively the Kowalskis. The final judgment awarded damages to the Kowalskis for false imprisonment between October 7th and October 13th of 2016, intentional infliction of emotional distress, wrongful death for intentional infliction of emotional distress, false imprisonment between October 18th and October 20th of 2016, false imprisonment on January 6th of 2017, medical negligence, battery on January 6th of 2017, battery for unspecified dates, and fraudulent billing. The trial court's erroneous interpretation and application of Section 39.2031A Florida statutes and the immunity afforded thereunder, as well as the trial court's erroneous denial of JHACH's motion for directed verdicts and JHACH's motion for a new trial, require reversal of the final judgment. Background. So they're reversing the entire thing. The verdict is vacated. There is no more $261 million. And it's going to go back for a new trial. And this is 2 years later. It's 2 years ago that the verdict came in on this case. And this is how slowly civil court moves, which I would submit to you is not that slow. In this case, it took 2 years. Here's the background. In the fall of 2015, Maya Kowalski was diagnosed with complex regional pain syndrome, CRPS. Beata Kowalski, Maya's mother and a nurse infusionist, became aware of CRPS prior to Maya's diagnosis through one of Mrs. Kowalski's patients. CRPS is a central nervous system disorder. It is characterized by severe regional pain with no apparent cause. Patients with CRPS experience an array of symptoms, including agonizing pain in the affected region or limb, extreme sensitivity to touch, light sensitivity, and lesions. Initial treatments for Maya's CRPS included warm water therapy, physical therapy, non-narcotic pain medications, and opioids. When the initial treatments failed to relieve Maya's pain and symptoms, Maya began receiving ketamine. This included Mrs. Kowalski taking Maya to Mexico, where Maya was placed in a 5-day K coma. I'm going to use K for the word that I just said because YouTube doesn't like the word. It's not my rules, it's their rules. For a period of approximately 8 months prior to her admission to JHACH in October of 2016, Maya was being treated with K infusions through a central venous port in her chest. The K infusions were authorized and overseen by Dr. Ashraf Hanna, a pain management doctor. Although Kay had been the longest used and most successful treatment for Maya's CRPS prior to her admission to JHACH. Maya's physicians had also prescribed other treatments, including hyperbaric oxygen and immune system stimulants. During most, if not the entirety of her treatment, Maya was unable to walk without assistance and was in a wheelchair. On the day before Maya's admission to JHACH, Dr. Hanna advised Mrs. Kowalski that he had given Maya the maximum dosage of K that could be administered and that it was not helping Maya. Dr. Hanna advised that Maya be taken to JHACH, footnote 1, which says Dr. Hanna did not testify at trial. On October 7th of 2016, Mr. Kowalski brought Maya, then 10 years old, to the emergency room of JHACH. Maya presented with excruciating pain. Upon Mrs. Kowalski's arrival at JHACH, she was adamant that Maya received K infusions, and although JHACH was able to confirm with Dr. Hanna that Maya had been in his care and had been receiving high dosages of K, the hospital emergency room notes state that dosages at the level demanded by Mrs. Kowalski could not be administered in the ER. Maya was ultimately admitted to the Pediatric Intensive Care Unit at JHACH, or PICU. Concerned about Mrs. Kowalski's demands for K and perceived inconsistencies between Mrs. Kowalski's recitation of Maya's medical history and JHACH's own observations, a social worker at JHACH, in accordance with JHACH policy, called the Department of Children and Families Abuse Hotline on October 7th of 2016. The following day, October 8th of 2016, JHACH contacted Dr. Sally Smith because of the suspected abuse. Dr. Smith, who had privileges at JHACH, is a pediatrician and was the medical director of the child protection team for Pinellas County at that time. Footnote 2. Child protective teams are used to supplement the assessment and protective supervision activities of the department. On October 9th of 2016, a second call from the social worker at JHACH was made to the department child abuse hotline. This second call resulted in an immediate investigation. It was on Netflix. Take Care of Maya? Okay, thanks. I was wondering where it lived. On October 13th of 2016, Maya remained at JHACH, but was taken into the department's custody. The department filed a dependency shelter petition requesting that Maya be placed in the shelter care of the department because Maya had been abused, abandoned, or neglected, or was in imminent danger of abuse, abandonment, or neglect. The department sought medical shelter care for Maya and requested no contact between Maya and Mrs. Kowalski, but supervised visits between Maya and Mr. Kowalski and Maya's brother. On October 14th of 2016, following a hearing on the department's petition, Maya was placed in the shelter care of the department. The dependency court order provided that Mrs. Kowalski was to have no contact with Maya pending psychological evaluations of both Mrs. Kowalski and Maya. Mrs. Profess is in the chat, and she says, as a patient advocate, I don't trust the medical community. That's interesting. The order further provided that the department would make all efforts to identify an appropriate person at JHACH to supervise visitations between Mr. Kowalski and Maya. Additionally, the order provided that in the event Maya's parents were unwilling, the department or the person primarily responsible of the care management of Maya was authorized to consent to ordinary and necessary medical examination and treatment of Maya. There's a footnote 3 here that says, Section 39.0143 defined as, quote, defined necessary medical treatment as the care which is necessary within a reasonable degree of medical certainty to prevent the deterioration of a child's condition or to alleviate immediate pain of a child. Thus, as of October 13th of 2016, Maya was in the custody of the department, and beginning on October 14th of 2016, Maya was under the jurisdiction of the dependency court. At trial, Mr. Kowalski testified that at some point between October 8 and 13, 2016, he and Mrs. Kowalski requested that Maya be released from JHACH and that JHACH subsequently threatened them with arrest if Maya were to leave the hospital against medical advice. Mr. Kowalski testified that JHACH advised him that Maya could not leave the hospital because Maya had to be safely weaned off medications, including K. Evidence at trial established that JHACH attempted to transfer Maya to another hospital, but that the Kowalskis would not consent to the transfer because the insurance codes on the transfer form indicated that Maya had Munchausen syndrome or conversion disorder, or was the target of Munchausen syndrome by proxy, and did not indicate that Maya was suffering with CRPS. Mr. Kowalski testified that he and Mrs. Kowalski would not sign the transfer form because they believed it would mean admitting guilt or blame. Footnote 4, which says, evidence established that prior to Maya's admission to JHACH in October 2016, concerns had been raised about psychological factors affecting Maya's physical condition by medical professionals who had treated Maya at Tampa General Hospital and Lurie Children's Hospital of Chicago. Without referencing the limitations and requirements of the dependency court orders, Mr. Kowalski testified that anything he brought into the hospital had to be approved, whether it was clothing, food, or letters. Food was required to be prepackaged and could not be homemade. Mr. Kowalski testified that during one of his visits, Maya had asked him whether Mrs. Kowalski was in a mental institution. When Mr. Kowalski asked why Maya would say that, Maya told him that a JHACH social worker assigned to Maya, Catherine Beatty, had told Maya that Mrs. Kowalski was receiving mental health treatment. Remember Catherine Beatty's testimony? This is bringing me back to the trial. I have PTSD from this trial, I think. This is where we got the phrase "for the love of the traveling Mary," because do you remember the woman, the beautiful woman with the hat on that testified at trial that they tried to bring the traveling Mary to visit Maya in the hospital and that they would not let the traveling Mary in? And they refused her getting communion? Yeah. This is going to outrage you guys if you were not here for the beginning of this trial and all of it. Go watch the playlist. The social worker was so horrible. Sally Smith and Catherine Beatty, both of them. Mr. Kowalski testified to additional statements made to him by Maya, including instances where nurses had told Maya that her illness was all in her head, and where Ms. Beatty had told Maya that she could be Maya's mother while Maya is there at the hospital. Oh yeah, I remember that. And then remember we watched portions of the videotaped depositions? It was cringe. Mr. Kowalski also testified regarding his own interaction with Ms. Beatty, wherein she asked him, "Did you ever consider divorcing your wife?" He responded, "What are you talking about?" And Ms. Beatty said, "Oh, forget it," and walked away. Mr. Kowalski relayed to Mrs. Kowalski what had happened during his visits with Maya and the information he had learned, right? And the argument was, these are the things that drove Beata Kowalski to take her own life because she felt that she needed to be out of the picture for Maya to get out of state custody. Although he was aware that Maya had been moved to a new room on October 18th of 2016, Mr. Kowalski testified that he was unaware that the new room, identified by JHACH staff as the EEG room, was under video surveillance until many years after the fact. Footnote 5, which says, JHACH's admission form includes the following language, quote, "I understand that closed circuit television monitoring of patients' care may be used during the course of treatment." He testified that he never saw Maya mistreated. Likewise, he never saw nurses taking actions that he considered to be cold or unusual. Maya testified at trial that the commode in the EEG room was far enough from her bed that she would have to stand up and walk to use it, which she could not do. Maya believed that the nurses wanted to provoke her in order to prove that she could walk. Maya testified that she was not permitted to speak with her mother and that this infuriated her. Although Maya was told that her pain was in her head and that she was making it up, Maya testified that she was not told that physicians believed that she had conversion disorder or Munchausen syndrome. One instance Maya relayed involved a specific nurse verbally accosting her for not moving during a bed change. Despite Maya advising the nurse that she could not walk, stand, or roll, the nurse said, "If you don't move right now or else." She recalled that the nurse yelled at her for quite a while, saying, "I know you can move. I know you're faking it. Just stand up. We all know." Remember that Maya Kowalski was 10. She was 10 years old. The Kowalskis are Catholic, and Maya testified that she was not permitted to receive communion from her parish priest. She did receive communion from a priest associated with JHACH. Maya believed that outside food, including the communion wafer, was not permitted because there was a fear that Mrs. Kowalski would tamper with it or somehow add ketamine to it. She did not testify to the requirements of the dependency court in this regard. Maya reiterated in her own testimony that Ms. Beatty had told her that Mrs. Kowalski was in a mental institution. Maya quickly learned that Mrs. Beatty's statement was false, and Maya believed the statement was intended to manipulate Maya into thinking that her mother was sick and therefore making Maya sick. Maya also reiterated that Ms. Beatty told her, "I'm not trying to be your mother, but I can be." Mrs. Kowalski was born in Poland, and Maya often spoke in Polish with her mother before her admission to JHACH. Although the dependency court eventually permitted Mrs. Kowalski to have supervised phone and FaceTime visits or calls with Maya, Maya was not permitted to speak Polish with her mother, and the calls were limited to basic and insignificant things. An audio recording was played of one conversation wherein a female voice advised Mrs. Kowalski that, quote, "We are not allowed to talk about the dependency case." After Mrs. Kowalski told Maya that as soon as the judge makes the decision, she would be able to see Maya again. But note 6. Maya recalled that this was Ms. Beatty redirecting the conversation. However, JHACH introduced into evidence an email from Charlotte Laporte, a department social worker assigned to Maya's case, stating that Mrs. Laporte redirected Mrs. Kowalski during that conversation. A final instance involving Ms. Beatty occurred when Ms. Beatty took photographs of Maya before Maya left the hospital for a dependency court hearing on January 6 of 2017. Maya testified that Ms. Beatty came to Maya's room and told Maya that if Maya wanted to go to court, she was going to have to be stripped naked and photographed. Ms. Beatty and a nurse did photograph Maya before court. Maya was wearing a training bra and shorts in the photographs. Again, she was 10. She understood that the photos were for purposes of the dependency case. Maya testified that she was in worse condition when she was released from JHACH in January of 2017 than when she was admitted. She also testified that by her 7th and 8th grade years in school, August 2018 through May 2020, she was participating in physical activities without restrictions. Ms. Beatty's deposition was played for the jury. She testified that she was a licensed clinical social worker at JHACH at the time of Maya's admission. Ms. Beatty testified that she was required to follow the dependency court shelter orders and that it was the dependency court that determined who Maya could see and when. She also testified that court orders provided general parameters, but that the department and JHACH, to some extent, determined how to implement those parameters. Ms. Beatty testified concerning the initial calls to the department abuse hotline and the rationale behind those calls. Footnote 7, which says, much of Ms. Beatty's testimony concerned actions authorized or required by Chapter 39 and responses to questions mischaracterizing JHACH's continued involvement as taking this child away from her parents. And that's in quotes. She also testified that 95% of the time that she saw Maya, Maya was up in her wheelchair. And the times that she would report extraordinary pain would be when she was prompted by her mother or, quote, if somebody asked her if she was having pain. She further testified that, quote, JHACH noted on several occasions where Maya was moving her legs, moving her hands without any pain. Maya was engaging in activities such as foosball, cutting out, and making crafts in the craft room. She was out playing the piano downstairs and often moved herself around the hospital. It was only after we gave that information to the department that Maya then decided or quit moving herself around the hospital for a few days. Yeah, 10. She was 10. And that's exactly what Catherine Beatty said. I remember it. Maya then decided or quit moving herself around the hospital for a few days. She was 10. And they wanted the jury to believe she was this, calculated patient. So much gaslighting in this trial, too. It's all coming back to me now. In one of her case notes, Ms. Beatty wrote, Maya told me that she was furious, angry, and in pain. She told me she can't talk or trust anyone, and that she knows there is court on Monday, and it's all lies. Ms. Beatty testified that JHACH has a policy against recording phone calls, and that she therefore objected to Mrs. Kowalski recording calls with Ms. Beatty. She also testified that whether Maya was permitted to see her priest was up to the dependency court. Ms. Beatty testified that the department asked JHACH, when they say department, it's the DCF, kind of like what we call in New York CPS, it's the Department of Children. The department asked that JHACH monitor Maya's calls, and that at times calls came through Ms. Beatty's phone, and she would put her phone on speaker to allow Maya to have the conversation. Ms. Beatty supervised phone calls between Maya and Mrs. Kowalski once the dependency court authorized supervised limited contact. At no time did the dependency court authorize in-person visitation between Maya and Mrs. Kowalski, right? Not until after she was dead. Well, after she was dead, she couldn't visit her, but after she was dead, that's when they finally released her from DCF custody. Ms. Beatty testified that in January 2017, JHACH's risk management department asked Ms. Beatty and another person to take photographs of Maya before she was taken into a January 6th dependency court hearing. The request for photographs had been made by an attending physician at JHACH. Ms. Beatty testified that in the professional context and in the foster care program, photographs are taken if there are injuries. She confirmed that at the time of the photographs, Maya was in the custody of the department, and that the department was, quote, getting ready to take their own pictures as well. No one explained to Ms. Beatty why she was taking photographs of Maya. Ms. Beatty noted that the email she received addressed concerns that Maya was self-mutilating and had scratches on her body. On January 6th of 2017, the dependency court ordered that Maya would remain sheltered at JHACH and set a February 2017 trial date. Now remember, she had been in the hospital since October. Mrs. Kowalski committed suicide the following day on January 7th of 2017, leaving 2 suicide notes. Those notes reflected Mrs. Kowalski's sadness and frustration with the dependency court proceedings and those involved with the dependency proceedings, including JHACH, the department, and Dr. Smith. One week after Mrs. Kowalski's suicide, on January 13th of 2017, the dependency court allowed Maya to be released from JHACH and to resume living with Mr. Kowalski, right? A week later, she was released. And so in some small way, maybe Beata was right. The dependency case was ultimately dismissed. During the months that Maya was sheltered at JHACH, she was weaned off the K, and the dependency court order releasing Maya from JHACH prohibited additional K treatments. Maya had been admitted to JHACH in severe pain, unable to walk, and receiving high doses of K. When she was discharged from JHACH, she was still in significant pain and unable to walk. At the time of the trial, the only medications she routinely took were Claritin, Flonase, and a sleep aid. She had been able to walk, run, and ice skate. Maya testified that she had experienced no CRPS flare-ups in the 3 years following her January 2017 discharge from JHACH. The Kowalskis filed their lawsuit on October 5th of 2018. Just hang on one second. The operative 8th amended complaint was filed on January 24th of 2023. More than 50 pretrial motions were litigated and resolved before this legally complex and emotionally charged case was heard by a jury beginning on September 14th of 2023. So we're talking about civil cases now, right? With the Karen Reed civil case. It was 5 years between the filing of the initial lawsuit and the trial date. It took 5 years. It's not uncommon. There are cases that go on for 10 before they get to trial. Hang on. And the trial was 2 months. During the 2-month trial, additional motions were filed and resolved, including multiple motions for directed verdicts. A directed verdict is when, in this case, the defendant, JHACH, the hospital, asks the court to direct a verdict in its favor based on either papers, like a motion to dismiss, or regardless of the jury verdict, we think that we should have won and you should have directed a verdict for us. On November 9th of 2023, the jury returned a verdict in favor of the Kowalskis on all remaining claims. Post-verdict, JHACH filed an omnibus renewed motion for a directed verdict, a motion for a new trial, and a motion for remitter. Remitter is asking to reduce the jury verdict award. The court denied, largely without elaboration, the renewed motion for a directed verdict and motion for a new trial. It granted, in part, the motion for remitter. The court entered the final judgment. The court then entered the final judgment. Oh, hey, Recovery Addict is here. Hi, Scott. We were just talking about you. Hey, Recovery Addict viewers. Thanks for coming on over. This is where Scott and I met covering this trial, and I just looked it up, and it was all the way back in almost exactly 2 years ago. 2023, 2-month trial. We love Scott. We love Recovery Addict. He's the best. Hey, guys. So remember, it was Judge Carroll, Judge Hunter Carroll, who did reduce the verdict a little bit, right? Because we covered that post-trial motion. And then it took 2 more years to get to this part. And here is the Florida Appellate Court's analysis. Hey, Glairs are here too. Hi, Glare fans. Hey, guys. Hey, guys. Hey. Roman 2, analysis, standards of review. Issues of statutory interpretation are reviewed de novo, meaning anew. There's your Latin lesson of the day. Quote, a trial court's decision on a motion for directed verdict presents a question of law, the sufficiency of a party's evidence that we review de novo. When considering whether the trial court should have granted a directed verdict, we must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. Our review of the denial of a motion for new trial is for an abuse of discretion. In reviewing an order on a motion for a new trial, an appellate court should consider the totality of all errors and improprieties. B, Section 39.2031A, immunity. Pretrial, JHACH moved for partial summary judgment based on the immunity afforded pursuant to Section 39.2031A. JHACH argued, as relevant to this appeal, that every claim against it, except the battery claims, was precluded as a matter of law because JHACH had reasonable cause to report suspected child abuse and was otherwise participating in Chapter 39 proceedings. The trial court granted in part and denied in part the motion based on its interpretation and application of Section 39.2031A to the Kowalski's claims. JHACH argued in its post-verdict motions that a new trial is warranted based on the trial court's narrow interpretation and erroneous application of the statutory immunity. On appeal, JHACH again seeks a new trial based on the court's erroneous rulings with regard to Section 39 and their pervasive impact on the trial. The trial court considered two sections of Chapter 39 and applicable precedent addressing the statutory language. Section 39.201A1, 201(1)A addresses mandatory reporting of child abuse and provides, in relevant part, quote, any person who knows or has reason to cause to suspect or has reasonable cause to back to one. I'm going to start again. Section 39 addresses mandatory reporting of child abuse and provides in relevant part, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent shall report such knowledge or suspicion to the department in the manner prescribed by subsection 2. Physicians, nurses, and hospital personnel engaged in the admission, examination, care, or treatment of persons, as well as other health or mental health professionals, are required to provide their names to the abuse hotline when making a report. Suspected child abuse by a parent must be reported immediately. Footnote 8. Footnote 8 says, notably, the department also bears responsibility under Section 39.201, which reads, if it appears that the immediate safety or well-being of a child is endangered, that the family may flee, or that the child will be unavailable for purposes of conducting a child protective investigation, or that the facts or otherwise so warrant, the department shall commence an investigation immediately, regardless of the time of day or night. In all other child abuse, abandonment, or neglect cases, a child protective investigation shall be commenced within 24 hours after receipt of the report. 39.201. 5. The shelter petition, in this case, alleged, and the dependency court found that shelter was appropriate based on evidence of abuse and imminent danger. And any person who is required to report known or suspected child abuse and who fails to do so commits a felony. Section 39 also addresses actions authorized or required by Chapter 39, as well as reporting child abuse, and provides, quote, any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment, or neglect to the department or any law enforcement agency shall be immune from any civil or criminal liability which might otherwise result by reason of such action. In construing Section 39.201(1)A, the trial court also considered a couple of cases that are named here. Both cases address only reports of suspected child abuse and the immunity afforded thereto. In Urquhart, the court concluded that, quote, there are two ways in which a doctor can be immune from civil liability for making an incorrect report of child abuse. Immunity exists as a matter of law if the doctor has reasonable cause to suspect that the child has been abused and makes a report of the abuse as required by law. In that event, there is no need to determine whether the doctor acted in good faith. Once reasonable cause has been shown, a reporter complying with the statutory mandate to make a report is by definition operating in good faith. However, the absence of reasonable cause does not prove liability. It merely removes the immunity that would otherwise apply as a matter of law. If the objective evidence does not support a conclusion that the doctor had reasonable cause to make the report, the doctor may nevertheless claim immunity from civil liability by showing that the report was made in good faith. Note 9 says, the trial court expressed trepidation in applying the Urquhart analysis insofar as Urquhart concluded that, quote, the immunity that is afforded to a medical doctor is not the same as that afforded to an ordinary citizen, where neither section 309-201, 39201 or 39203 differentiate between doctors and ordinary citizens, except that the former are required to give their names when making a report, while the latter may remain anonymous. While we might agree with the trial court on that narrow issue, application of the statutory immunity as between doctors and ordinary citizens is not among us, not before us. It's not before us. The facts of this case, where we go. Citing Urquhart, the court in Ross likely concluded that if a reasonable basis existed to report child abuse, the motive in making the report is irrelevant. Based on the facts before it and the above cited precedent, the trial court determined very easily that JHACH had reasonable cause to report suspected child abuse to the department hotline. Accordingly, the trial court found that JHACH was entitled to Section 39 immunity from any civil claim which might otherwise result by reason of the reports. But the court said nothing of immunity for claims resulting from participation in good faith in any act authorized or required by Chapter 39. The facts of this case are unusual in that the reporter, for purposes of Sections 39, remained a participant in Maya's care beyond the initial shelter hearing and was required to comply with the dependency court orders by virtue of the department designating Maya's placement with JHACH. As the shelter placement, JHACH was required to implement the dependency court orders. Those orders required JHACH to comply with visitation guidelines set forth in the orders, as well as to manage correspondence between Maya and Mrs. Kowalski. Footnote 10. The dependency court orders included directives on screening visitors through the department and who specifically would be permitted visitation. Moreover, the orders directed that the court would not micromanage or countermand JHACH's policies, and that absent clear and compelling reasons, JHACH's staff was to be free to address the medical needs of their patients without the court, the parents, or others interfering with their professional judgment. JHACH was required to take part in the sheltering of Maya by virtue of the shelter order entered October 14th of 2016. The department sought to have Maya sheltered based on ongoing abuse and imminent danger. The dependency court sheltered Maya, and the department was authorized to determine her placement. The department placed Maya at JHACH for ongoing medical treatment, including psychological evaluation and weaning off K. Within the text of Chapter 39, the legislature established its intent expressly. The purposes of this chapter are to provide for the care, safety, and protection of children and to prevent the occurrence of child abuse, neglect, and abandonment. The legislature further stated its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purposes. Courts may not extend, modify, or limit the statute's express terms or its reasonable or obvious implications, because to do so would be an abrogation of legislative power. Moreover, all parts of a statute must be read together in order to achieve a consistent whole. Effect must be given to every clause of the statute and meaning given to all of its parts. Here, the trial court erred by not considering the entirety of Section 39-2031A and its application of the facts of this case beyond JHACH's immunity from claims premised on or immediately resulting from the reports of suspected child abuse. And nothing in the record suggests that JHACH's participation in implementing the dependency court orders, as it was required to do, was not done in good faith. The statutory scheme at issue is intended to protect those who might be overzealous in protecting children from potential abuse. This is not to suggest that Section 39-203A1 provides absolute immunity. It provides immunity from liability that might otherwise result from good faith reporting or good faith participation in acts authorized or required by Chapter 39. There are complexities created by the interplay of Chapter 39 with the claims raised in this case. We are aided in interpreting and in applying Chapter 39 by the amicus curiae briefs filed by the American Academy of Pediatrics, the Children's Hospital Association, and the Florida Hospital Association. Florida Hospital Association articulated its concerns with the trial court's ruling in this case. Let me just point out to you that they all have a vested interest in hospitals not having to pay very large judgments. The trial court found as a matter of law that JHACH had a reasonable basis for suspecting that their patient was the subject of child abuse, that JHACH acted in good faith in reporting that suspicion, and that JHACH could not be held liable for any cause of action directly arising from sheltering the child pursuant to a court order. Unfortunately, these findings were rendered meaningless at the trial itself when the court permitted the Kowalskis to attack JHACH's basis for suspecting abuse, its motives for reporting that suspicion, and present evidence to the jury of the psychological impact of the court-ordered sheltering period. The actions of JHACH with respect to their good faith, mandatory reporting, were repeatedly called into question and leveraged by the Kowalskis in their effort to secure a finding of civil liability and an award for damages. The trial court found that Section 39-2031A immunity flows for any civil liability that may result by reason of the child abuse report, and that without question, an investigation, shelter, or removal of custody and prohibiting visitation are all outcomes that logically could occur from a report to the abuse hotline. Footnote 11. Whether the trial court's interpretation is correct in this respect has not been raised by the parties to this appeal. We note, however, that the plain language of the statute provides immunity from civil liability resulting from good faith abuse reports. Whether civil liability results from, or as the trial court found, flows from the abuse reports or from other acts authorized or required by Chapter 39 is not a distinction we must draw in this case because JHACH was required to comply with dependency court orders as a matter of its good faith participation in the Chapter 39 proceedings, regardless of whether it's compliant with court orders flowed from the abuse reports. And so this court is saying, because the hospital is a mandated reporter, and because the dependency court issued orders and ordered that the hospital shelter Maya, the hospital gets immunity because they were required to follow the dependency court order, and because they made the initial complaints of child abuse in good faith. The trial court implicitly recognized that dependency court orders, that is, those sheltering a child and restricting or prohibiting visitation, may result from the reporting and investigation of abuse. Yet the trial court failed to give effect to its interpretation by permitting the jury to hear significant and inflammatory testimony concerning the restrictions put in place by the dependency court and the impacts those restrictions had on the Kowalskis. For example, Mr. Kowalski testified that Mrs. Kowalski lost consciousness and fell to the floor upon learning that she was not going to be able to see Maya, and that during the time she was unable to see Maya, Mrs. Kowalski deteriorated. She was losing hope. He repeatedly testified to the profound impacts of the dependency court orders on Mrs. Kowalski. Maya also testified to the impacts of the dependency court orders on her, from anger and not being able to speak with or see her mother to feelings of isolation. Maya testified that she was suspicious about the comments made to her and the restrictions placed on her. No one ever directly told her what was going on, and she had to figure out for herself that she was being stripped from her family. She testified that JHACH provided her with a My Care journal, and that in it she listed names of JHACH doctors and nurses with notations and drawings. I was trying to get out of the hospital, and I'm 10. So I'm thinking if they think I like you, then I'll get out. Footnote 12. This appellate court says in its footnote 12, the closing arguments were also inflammatory. Counsel for the Kowalskis argued that JHACH took Mrs. Kowalski out of the game by changing its diagnosis and treating the Kowalskis like criminals. Counsel then went on. I'm sorry, hold on a second, I need a sip. I'm getting parched. Counsel then went through JHACH's defenses, because if we get rid of the defenses, then all that is left is the Kowalskis' case. Counsel for the Kowalskis argued that something happened between hiccups. Hold on while I get rid of my hiccups. Hang on. Counsel for the Kowalskis argued that something happened between Mrs. Kowalski and JHACH that ticked JHACH off, causing JHACH to call the department, and that JHACH was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job. They argued that JHACH calling the department hotline was retaliatory against Mrs. Kowalski, and that she committed suicide because she knew that if she did not take drastic action, Maya would end up in some kind of foster care or die. The trial court erred by not giving effect to that portion of the statute to which it assigned meaning, and it further erred by not giving meaning to all words within the statute. Section 39-2031A provides immunity from civil liability, which might otherwise result by reason of both reporting in good faith any instance of child abuse and participating in good faith in any act authorized or required by Chapter 39. 91 of Maya's 97 days in JHACH were the result of dependency court orders wherein the department had been given placement and care responsibility of Maya while she remained under protective supervision. JHACH argues that the trial court errors in interpreting and applying Section 39-2031A immunity should result in a new trial for all claims. Footnote 13. We note that JHACH has not argued that evidence of good faith participation in actions authorized or required by Chapter 39 is not admissible because such actions cannot form the basis for liability. The FHA, however, contends that if a party is immune from any civil liability that might otherwise result by reason of certain conduct, then evidence of such conduct should not be offered as part of an effort to support a finding of any form of civil liability, and that offering such evidence creates an obvious and significant danger of unfair prejudice, confusion of issues, and misleading the jury. We agree that the trial court's rulings on Section 39203(1)A immunity permeated the entire trial. A new trial is required on all counts not otherwise disposed of by this opinion. There's 25 more pages yet left. But the court's telling us what they're going to do. It's going back for a new trial for all the counts that they're not outright dismissing in this opinion. Let's go to the chat for a minute. Thanks, El Gore, for becoming a new member. Welcome. Living that GP life sloth style. Thank you for your 10. Says just had surgery this morning and literally smiled for the first time today when I saw that you were live. Oh, I'm sending you all the healing vibes. Hope you feel better soon. This will be a perfect distraction for me. Thank you, Melanie. I love you with all my heart. Thank you so much. Free super chat and wishing you all of the healing vibes in your surgery recovery. Lynn's been here for 14 months and she says, Sally Smith, the ultimate God complex doctor. Sarah Kelly says, I worked at this hospital as a direct care provider for 10 years. We were all horrified by the documentary. We were asked not to watch it or discuss. That's interesting, Sarah Kelly. Thank you for your 5. Mathis Grease says, I thought this took time to be released because it would explain things, but it's just confusing. They ignore a lot of arguments from the answer brief. Well, we got 24 more pages to go. Maybe you did read the whole thing yourself. And so that is what you're saying. Kathy Belodo became a new member. Welcome, Kathy. Kathy Bilodeau, why does your name sound so familiar to me? Did we cover a case with the Bilodeau in it recently? I think we did. I don't want to out you, but I think we did. Let's see what you guys are saying. Rhonda says, this is when I first started watching it. It was 2 years ago. Can you believe it? 2 years ago. Thank you, Lisa, for buying me a matcha latte. I appreciate you. Cyber Chicken Boston, thank you so very much for your Venmo. She said this is a new case for her. You're going to get outraged. They were okay. That's a great question, Emma. Emma says, were they appealing the monetary amount or the entire verdict? They already appealed the money amount once, I believe. And this is the entire verdict they're appealing. The entire thing. And sending it back for a new trial. Yes, Julie. Julie says, I'm not sure if I understand correctly or not. Was the plaintiff, Maya's family, able to respond to this before trial? Yeah, there were appellate briefs that were filed that we did not go over. We've covered a lot of other appeals and both sides get to file their briefs. Then there's oral argument. We've watched a lot of oral arguments. And then this is the decision resulting from that oral argument. I think there were oral arguments in this, right? We did not watch them together. And as Harry Potter's beard points out, yes, unfortunately, judgments can be overturned. Verdicts can be overturned because of questions of law. And that is what the appellate court decides, the questions of law, whether there were certain things allowed into the trial that should not have been allowed in, whether they were more prejudicial because they came in than probative, whether the amount is too much, whether as a matter of law, certain claims should have been dismissed. Teresa Fusco, that's what it was. Richard Belodo was just arrested in the murder of Teresa Fusco, the 1984 cold case from Long. Thank you, Mrs. Sarcasm. Thank you. Because that would bother me all day. And this is what appellate courts do. And remember, this is a civil case, not a criminal case. Right. Letter Rose by Better Rose says Judge Carroll was so good, seemed to make all the appropriate rulings. Yeah. People say follow the money. And Kathy Bilodeau is like, no, I am not related to that guy. I am not related to that guy who just got arrested 40 years later for the murder of a girl from 1984. Kathy, change your name. Change your name. That's right. The defense attorney, there was an email that surfaced from one of the defense attorney who called the jurors a bunch of bus stop people. And he attacked juror one and his wife. That is correct. It's all coming back to me now. Follow the money, right? Remember, plaintiffs' attorneys in cases such as this take these cases on contingency, which means plaintiffs' attorneys do not get paid until there's a settlement or there's a verdict and the money is paid. And so Maya's attorneys have not been paid at all. And they spent a lot of money. Didn't Greg Anderson say that he took a mortgage out on his house to fund this case? Because that's what plaintiffs' attorneys do. They fund the case, they pay for all the expenses, and then at the end of the case, they take their expenses back and then they get paid a third. Usually it's a third. Some states you can get up to like 50% if the case goes to trial. So they've been paid nothing. And if it's going back for a new trial, it begs the question of, will the same attorneys be able to fund this case again? Yeah, they called the jurors bus stop people. There was an email that surfaced, right? What was the name of that attorney that called the Yeah, no way Greg Anderson is taking this case again, but I think he's not on the case anymore. I think the family fired Greg Anderson and hired Nick Whitney. You guys can tell me if I'm wrong. They were together before. They now have separate firms. I don't know if they're still together anymore, if they made up, if they kissed and made up. I think they were suing each other at one point. Right. Amy Jones says, how can I remember so much of this trial and not remember what I had for breakfast? I know. Jordy said this is literally going to piss everybody off. I know. This is when we started to become outraged. And then Karen Reed came along in January of 2024. And we redirected our outrage from Maya because Maya got a great result. She got a jury verdict of $261 million, right? That was November of 2023. And then in January 2024, we pivoted right to Karen Reed. So we've been outraged for 2 full years and then some. It was Shapiro. That was his name, Shapiro, right? I think so. Hughes called them bus stop jurors in an email, I think, says Zimmy. Zimmy used to have the name. Weren't you Zimmy from the bus stop for a while? You guys are OGs. Yes, I'm Gumby, damn it, said the lawyers said that juror number 1 was a Nazi because of how he wrote the number 2. Right. And then they pulled, this is all coming back to me now. They pulled their legal theories off of Reddit threads. Do you remember? We found the Reddit threads and they literally pulled their legal theories and put it in their papers, all the theories they were finding on Reddit. Right? Shapiro wasn't the one. It was Hughes. Yes. They thought he was a Nazi from the way he wrote his number 2. Oh my gosh. This Susan says, be very careful when taking your children to a hospital. Yep. Yep. The Goodmans are here. And she or he, I'm not sure if it's Brian or D. Somebody's rage folding laundry over there in the Goodman household. Yep. The Reddit forum motions. You remember that. Catastrophe. I don't know, Michael. What were you watching back then? Was it before you discovered me? And was it before that I was part of your everyday life, Michael L? Says, how did I not want to follow this trial back then? What could I have been watching? The Kowalskis fired them and went with Nick instead. Oh, look at Scott. Merch, makeup, and more. Scott Messerschmidt and one of our amazing moderators here put up my Amazon link. On the members only live, we went through all of like the stuff on the Amazon list and all of my favorite things. And wasn't that fun? I'm going to pin it to the chat in case you want to go look. It's also a good way to support the channel. You just click into my link and then just do your regular shopping on Amazon. And I get like 50 cents credit on Amazon at the end of the month and it costs you nothing. It was right after the Murdoch trial, says Deanne. And with every case we cover, they get crazier and crazier. And now you can see why I pick the cases that I do. You know? Hold on. That's right, Lucy. Shapiro couldn't fathom the idea of a wife, the wife of juror number 1, hippo lover, having her own opinions in social media accounts from the husband. That's right. Yeah, Nick Whitney was a JAG lawyer too. He was the numbers guy, says Stina G. Are you rage coloring your cupcake coloring book, Harry Potter's beard that Emily C made? I'll allow it. Everyone, please hit the like button to hit the to help to push the video out. Because I've said suicide and abuse so many times that I know YouTube is going to say that I'm unfriendly to advertisers. And Sassy Hound says, I literally sobbed tears of joy after this verdict. The Dracula, says Melissa. What the Dracula? Somebody else mentioned the Dracula. Refresh my recollection about the Dracula. Amy said, okay, it was Ethan Shapiro who busted out of the courtroom calling Maya and her family curse words. Dracula trying to stay buried. Yes, yes, yes. Right, right. I agree with you, Crunchy Frog. I think the judge in the dependency case, Crunchy Frog says, screwed up more than anyone and nothing will happen to him. Right. And Brian, Mr. Goodman just sent a Venmo and said, it's Deanna folding laundry. They often compete with their super chats, and I'll allow that too. And he's so happy that she's doing laundry, that she's folding the laundry, and that you're an amazing, he says you're an amazing folder, Mrs. Goodman, says Mr. Goodman. And he's so happy that you're doing the folding. He appreciates you so much. He loves you so much. They watch me on their date nights. So anything I can do to help their relationship is fine with me. Dracula trying to stay buried. Yep. Zambi Mom is also rage coloring. I need crayons. I need to color. Yep. The Dracula that had been buried long ago. The Dracula they thought they buried. Yep. Zambi Ma'am says, yep, they knocked somebody over in the hallway. Jen loves folding clothes. Oh, that's enough. I forgot. I don't think I put this on my Amazon. Do you have a folding board? Sorry to digress for 1 minute, but this makes me mad. So I have to just, Jen, I forgot to put this. I don't know if it's on my Amazon list that is now pinned in the chat, but I have this amazing folding board that you put your t-shirts in it and your other shirts and you fold it up and you box it and you slam it down and you have the best folded shirts ever. I think it's in my Amazon list, but I'm not sure. If it's not, I'm going to have to remind myself to put it in there later because everyone needs a folding board for $18.99 because I hate folding so much. I really suck at it. Especially I hate folding fitted sheets. I suck at that too. I've watched every video on it. You do have it, but you freehand it. I can't find my folding board right now. It upsets me greatly. Hughes thought he had buried the Joint Commission report that Dr. Joe shined the light on. Right. Pink 4x4 lady says. Sharing Sharon is part of our Rage Crochet Club. And right now, she's been here for 24 months. She was here during the first, this Maya trial. And that's when we started the Rage Crochet Club, right? Sharon is like the president. And she's finished a beautiful cardigan. And now she's on another cardigan. Yeah. Next time I visit my college students, I'm going to see if they stole my folding board. But I think I sent them each one at college. I think that the twins each have a folding board that I sent them at college because it makes folding more fun. And Moslin is also crocheting a cardigan. And the Joint Commission Dracula report was withheld by the defense. Yeah, there was a lot of shenanigans, right? Withholding evidence. Yes. And the reports. You guys remember. You're on it. All right, here we go. Next section, false imprisonment from October 7th to 13th of 2016. The trial court denied JHACH's motion for a directed verdict as to the false imprisonment claim for JHACH's actions between October 7th and October 13th of 2016. This was error. Footnote 14. Oops. Although JHACH sought summary judgment for this false imprisonment claim, as well as the other false imprisonment claims on the basis of Section 39 immunity, JHACH does not challenge the court's denial of its motion for summary judgment. The only challenge it raises on appeal as to the October 18th through October 20th and January 6th false imprisonment claims concerns punitive damages. The essential elements of a cause of action for false imprisonment include 1, the unlawful detention and deprivation of liberty of a person, 2, against that person's will, 3, without legal authority or color of authority, and 4, which is unreasonable and unwarranted under the circumstances. All elements must be proven for a plaintiff to recover on a false imprisonment claim. The October 7th through October 13 allegations stem from JHACH's refusal to release Maya from the ER in the PICU. JHACH argues both that it had legal authority and that there was no evidence that keeping Maya in its care was unreasonable and unwarranted under the circumstances, whether because of Maya's pain levels and overall health at the time, or because of the suspected child abuse. We need only consider whether the hospital was without legal authority or color of authority, a question of law, to resolve this issue. JHACH's legal authority or color of authority stems from Section 39, which reads, any person in charge of a hospital or similar institution or any physician or licensed healthcare professional treating a child may detain that child without the consent of the parents, caregiver, or legal custodian, whether or not additional medical treatment is required, if the circumstances are such, or if the condition of the child is such that returning the child to the care or custody of the parents, caregiver, or legal custodian presents an imminent danger to the child's life or physical or mental health. We are mindful that Section 39 also requires that any such person detaining a child shall immediately notify the department and that the department shall immediately begin a child protective investigation in accordance with the provisions of this chapter. Beyond the initial detention and reporting to the department, the legislature has placed no burden on the person detaining the child. Instead, it has placed the burden on the department. Quote, if the department determines, according to the criteria set forth in this chapter, that the child should be detained longer than 24 hours, it shall petition the court through the attorney representing the Department of Children and Families as quickly as possible and not to exceed 24 hours for an order authorizing such custody in the same manner as if the child were placed in a shelter. Certainly, Section 39 provides color of authority for JHACH's detention of Maya in the ER and PICU during the period between the first and second reports to the department. And following the second report on October 9th of 2016, the department instituted its investigation. Moreover, JHACH's actions were authorized or required by Chapter 39, and there's no evidence that his participation was not in good faith, particularly where the trial court concluded that as a matter of law, JHACH had reasonable cause to suspect child abuse. As such, JHACH is immune from liability resulting from its detention of Maya between October 7th and October 13th of 2016. Meaning they can't be sued. They're immune. We're dismissing all of those counts. And you can't even get a new trial on them. That's what this appellate court is saying. Because there was a court order to keep her there. Accordingly, JHACH's motion for directed verdict on the claim of false imprisonment for the period of October 7th to October 13th should have been granted. Footnote 15. JHACH's issue concerning the corresponding motion for directed verdict on punitive damages is therefore rendered moot. So there was also a punitive damage award for the false imprisonment between those dates. And so therefore, because this court is finding, this appellate court says, as a matter of law, Judge Carroll should have thrown that out. We don't need to decide about the punitive damages. D, intentional infliction of emotional distress, or IIED. Beata Kowalski. This is Beata Kowalski's intentional infliction of emotional distress claims. 2 claims of intentional infliction of emotional distress, IIED, specific to Beata Kowalski, were resolved by the jury in favor of the Kowalskis after the trial court denied JHACH's motion for directed verdicts. JHACH contends that its motions for directed verdicts should have been granted because the Kowalskis failed to present evidence of conduct directed at Mrs. Kowalski, and the Kowalskis' evidence was insufficient as a matter of law. We agree. Footnote 16. We therefore decline to address JHACH's argument that Florida does not recognize IIED suicide. This is one of the arguments for the defense that I did agree with. And so I'm not surprised to see this tossed by the appellate court. I was surprised that it made it to the jury, but let's hear their reasoning. To support a claim for IIED, a plaintiff must prove. So keep this in mind because we're also covering the Karen Reed civil trial. And in the Karen Reed civil trial, the O'Keeffes are alleging intentional infliction of emotional distress by Karen Reed against the niece, and I think also against Paul and Peggy and Mr. O'Keefe for trying to spin a false narrative. I have to go back and look at the papers, but just keep in mind now what a plaintiff must prove to support a claim for intentional infliction of emotional distress. Because in the Karen Reed civil trial, the judge ruled on the tossing of those claims only based on the papers. There has not been any discovery yet. There has not been depositions yet. That was an initial motion based only on what was in the 4 corners of the complaint. And so that judge may change his ruling after all the discovery is done. But here is what a plaintiff must prove to support a claim for intentional infliction of emotional distress. Number 1, the wrongdoer's conduct was intentional or reckless. That is, he intended his behavior when he knew or should have known that emotional distress would likely result. And remember, this is also a Florida case, so the law may be a tiny bit different in Florida than it is in Massachusetts, but just get the general gist of it. 2, the conduct was outrageous, that is, as to go beyond all bounds of decency and to be regarded as odious and utterly intolerable in a civilized community. 3, the conduct caused emotional distress. And 4, the emotional distress was severe. The trial court must make the initial determination on a motion for a directed verdict that the evidence presented meets that high standard. And remember, I think there was something about like text messages between the doctors and maybe the nurses about, oh, what if she kills herself kind of stuff. But we'll read on and see what this court says about it. And because the outrageousness test is objective, testimony as to the plaintiff's beliefs on whether the defendant intended to cause emotional distress is of no moment. Likewise, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort intentional infliction of emotional distress occurred. As relevant to the estate's IIED claims, in order to state a claim for IIED based on one's own emotional distress, a plaintiff must be present when the alleged extreme and outrageous conduct is directed toward a third party. Otherwise, the conduct alleged to be outrageous must be directed at the plaintiff. And then they go through the Florida case law, and I'll scroll through slowly so that you can read up on that if you like. Stated differently, if the plaintiff is not present to witness the outrageous conduct, the plaintiff must have been the target of the outrageous conduct. The Kowalskis presented no evidence that Mrs. Kowalski was the target of any of the conduct alleged to be outrageous. Rather, the heart of the Kowalskis' claim, repeated in various ways throughout multiple bench conferences and asserted before the jury, was that the separation of mother from child with knowledge by both and without the ability to combat it was outrageous. The Kowalskis argued, quote, a plan that is told to the mother that we're going to take away your child and there's nothing you can do about it. The real outrageousness is the systemic nature of the actions against Mrs. Kowalski through this, and everything, every contact that she had and everything she learned reinforced that there was a plan to take her daughter away, and that is outrageous in our society. The Kowalskis contended that there were concerted efforts to raise the pressure on Mrs. Kowalski. Quote, if this doesn't get her, let's suggest that Mr. Kowalski get a divorce. And if this doesn't get her, let's tell Maya that I'm going to be your mother. And that was in quotes. The Kowalskis acknowledged that these statements were not made directly to Mrs. Kowalski because she wasn't allowed in the hospital, but were funneled to her through a proxy for which was her child or her husband. That Mr. Kowalski or Maya relayed what they had seen or experienced is not evidence that JHACH's actions were directed to Mrs. Kowalski. And there was no evidence that Mrs. Kowalski was somehow the target of statements made to either Maya or Mr. Kowalski. Moreover, the trial court recognized that the allegations in the operative complaint were insufficient when it granted JHACH's pretrial motion to dismiss the IIED claim as to Mr. Kowalski. With the exception of actions immune under Sections 39 and the assertion that Mrs. Kowalski suffered from Munchausen syndrome by proxy, there is little difference between the allegations the trial court found legally insufficient as to Mr. Kowalski's claim and the evidence presented to the estate's claims. The Kowalski's evidence was legally insufficient to survive directed verdict. The motions for directed verdicts on the IIED claims specific to Mrs. Kowalski should have been granted. And this court is throwing out those claims as well. Section E, intentional infliction of emotional distress claims with regard to Maya Kowalski. In denying JHACH's motion for directed verdict specific to Maya's IIED claims, the trial court considered evidence for which JHACH should have been immune from liability and evidence of other pleaded torts. This was error. We reiterate that the actions for which JHACH should have been immune pursuant to Section 39 cannot be used to establish liability. The department placed Maya with JHACH. JHACH's participation in the Chapter 39 proceedings, as well as its initial reports of suspected child abuse to the department, pervaded the Kowalskis' evidence of IIED against Maya. The trial court was required to consider which of JHACH's actions could have been immune from liability and which actions could support the independently pleaded tort of IIED. Medical professionals' disagreements about a complex medical case and perhaps overzealous implementation of dependency court orders are not acts intolerable in a civilized society or community. Good faith actions to protect children are neither utterly intolerable in a civilized community nor beyond all possible boundaries of decency or bounds of decency. Indeed, Section 39 immunity protects those who might be overzealous in protecting children from potential abuse. To the extent JHACH took actions within its legal rights under Chapter 39 and otherwise, it cannot be liable for intentional infliction of emotional distress. As to Maya. Additionally, IIED conduct must not be violative of any other recognized tort. That is, the facts upon which it is based must be independent of any other alleged tort. Here, the Kowalskis relied upon evidence of other pleaded torts in order to establish the IIED claims. Or claim. The law is clear, however, that the evidence supporting Maya's 3 false imprisonment claims, as well as her battery claims and medical negligence claims, cannot also be used to meet the legal threshold for her IIED claim. Footnote 17, which says further, evidence supporting the negligent hiring and supervision claims cannot be used. That claim was resolved in favor of JHACH. And while the Kowalskis argued that the evidence taken as a whole indicates that there was a desire and plan on the part of Ms. Beatty to separate Maya from Mrs. Kowalski, and that there was a plan by the hospital to force Mrs. Kowalski and Maya and Mr. Kowalski to change their story to the extent that such evidence is not subject to Section 39 immunity, there is no evidence of any such concerted effort. The subjective response, moreover, the trial court granted summary judgment in favor of JHACH on the Kowalski's conspiracy claim pre-trial. And so this appellate court throws that claim out as well. F, medical negligence, apparent agency. JHACH contends that the trial court erred in denying its motion for a directed verdict on the narrow issue of apparent agency as it relates to Dr. Smith in the Chapter 39. Otherwise, immunizes Dr. Smith's actions such that JHACH cannot be held liable for those actions. We agree. Wow. An apparent agency exists only if all 3 of the following elements are present. A, representation by the purported principal. B, a reliance on that representation by a third party. And C, a change in position by the third party and reliance on the representation. Deanne B says, this all makes me feel like I have made some false memories of watching this trial. I know. Refresh my recollection, chat. Was Sally Smith let out individually or settled with before the trial? Because this appellate court is saying, yeah, we're not going to hold you responsible for Sally Smith because you have immunity from that too. Mr. Kowalski testified that he was unaware that Dr. Smith was not a JHACH doctor at the time he first met her, but he could not specify the date. He testified she was wearing a white lab coat when she came into Maya's room and started asking questions. Maya testified that she was unaware of who Dr. Smith was or in what capacity she was questioned Maya's father. She sure was, right? I can't remember if she was let out or they settled with her. Same with Beatty too, right? She settled. Okay. Well, if she settled, then at least the Kowalskis got some money. And that would have been money from Sally Smith or her insurance company. So that's something, right? I mean, I don't know how much it could have been. An email dated October 12th, 2016 from Mrs. Kowalski's email address was entered into evidence. In that email, Mrs. Kowalski reported that on October 11th, 2016, she and Dr. Sally Smith, who was sent by the department to investigate the possible child abuse or neglect, had a second visit at which Mrs. Kowalski described Maya's illness and the doctors involved in Maya's case. In Maya's care. She settled. All right, thanks, you guys. Thus, no later than October 11, 2016, Mrs. Kowalski was aware that Dr. Smith was acting in her capacity as a child protective team physician. And certainly by the October 14th shelter hearing, Mr. Kowalski was also aware. The Kowalskis presented no evidence that they materially changed their position prior to October 11 or October 14 on the basis of Dr. Smith being an apparent agent of JHACH. Kristen says, I wonder if this would have been different if the lawyers weren't fighting with each other. No, I don't think that has anything to do with this. The appellate court would not take any of that into consideration. They're concerned with the law. And you mean the plaintiff's attorney fighting amongst themselves, I think is what you mean, right? Not the plaintiff's attorneys fighting with the defense attorneys, because that's to be expected and natural. Rather, the Kowalskis acknowledged that they were unaware that JHACH had given Dr. Smith full access to Maya's medical records at the time such access was provided. The apparent agency theory should have been rejected as a matter of law by the trial court, and a directed verdict as to that specific claim should have been granted. So this court is throwing that out as well, saying the hospital can't be liable for what Dr. Smith did because they knew she was acting as an agent of the DCF, not the hospital. Nonetheless, even were Dr. Smith an apparent agent of the hospital because Dr. Smith was the CPT medical director, she was authorized by Chapter 39 to take the actions she took. Her actions would not subject JHACH to liability unless JHACH was not participating in good faith in acts authorized by Chapter 39. And this court has already said, we believe the hospital was acting in good faith. And they were just doing what the dependency court told them to do. They were just following orders, boss. It was the Kowalskis' burden to prove that either JHACH was not participating in good faith in authorized or required acts, or that Dr. Smith was not acting in her capacity as the Child Protective Team medical director. In admitting evidence of Dr. Smith's actions without proper consideration of the statutory immunity, the trial court relieved the Kowalskis of their burden. Punitive damages, Section G. JHACH contends that the trial court erred in denying its motion for directed verdict on the issue of punitive damages as to the false imprisonment and battery claims, footnote 18. Although our reversal of the judgment as to the October 7th through 13th false imprisonment claims moots the issue specific to that claim, we would have otherwise concluded that directed verdict was warranted as to punitive damages because JHACH's actions during that period do not meet the definition of either intentional misconduct or gross negligence. And in Florida, those are the only two ways that you can get punitive damages, is if you prove that what the defendant did was egregious intentional misconduct or gross negligence. Quote, in all civil actions, the plaintiff must establish at trial by clear and convincing evidence its entitlement to an award of punitive damages. And a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. Clear and convincing evidence and intermediate burden of proof means clear and convincing evidence requires that the evidence must be found to be credible, the facts to which the witnesses testify must be distinctly remembered, the testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in issue. And that last sentence was italicized by the court. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established. I just want to tell you, as a civil litigator for over 30 years, that punitive damages oftentimes are overturned or reduced to some extent, most of the time. Most of the time, a civil defendant will not just willingly pay an exorbitant number on punitive damages without looking for some sort of lesser type settlement or some appellate court to reduce or overturn it. So this is not uncommon. In the case of an employer, principal, corporation, or other legal entity, punitive damages may be imposed for the conduct of an employee or agent only if the conduct of the employee or agent constitutes intentional misconduct or gross negligence, and the employer, principal, corporation, or other legal entity actively and knowingly participated in the conduct. B, the officers, directors, or managers of the employer's, principal, corporation, or other legal entity knowingly condoned, ratified, or consented to such conduct, or so they either knowingly participated, they consented, or they engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injuries suffered by the claimant. And then they go on to define intentional misconduct, meaning the defendant, JHACH, would have to have actual knowledge of the wrongfulness of the conduct and the high probability that the injury or damage to the claimant would result, and despite that knowledge, intentionally pursuing that course of conduct, resulting in injury or damage. Gross negligence is defined as a conduct so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. As to the January 6th battery and false imprisonment claims, Ms. Beatty testified that she was told to take photographs of Maya before Maya could leave the hospital for the dependency court hearing. The Kowalskis presented evidence that a risk management analyst within the risk management department of JHACH directed the actions on January 6th. Evidence established that it was JHACH's policy that the risk management department reports to senior counsel and then senior counsel reports to the president of JHACH. Footnote 19. There was also evidence that JHACH's risk management committee does not function in real-time decisions and meets only quarterly. Oh, remember that? Remember that testimony? That they had no idea what was going on. They only meet quarterly. They didn't know. There was no clear and convincing evidence that JHACH actively and knowingly participated or engaged in intentional misconduct or gross negligence. Likewise, there was no clear and convincing evidence that the actions in question in this case were relayed to senior counsel or to the CEO, much less that anyone ratified or condoned the actions other than the risk management analyst. Before one may infer that a principal ratified an unauthorized act of his agent, the evidence must demonstrate that the principal was fully informed beyond having simple constructive knowledge that he approved of the act. Cameron says, who's paying this judge on the down low? This is a whole panel of appellate judges, so I think there were 7 of them. I'm not exactly sure how many, but we'll find out at the end when we see who signed it. And there was no evidence that a risk management analyst satisfies the statutory requirement of officer, director, or manager of employees. Finally, to the extent that the Kowalskis argued ratification after the fact, actions taken after the happening of a tortious act are not admissible on the issue of punitive damages, nor can those subsequent actions form the basis for bringing such a damage claim. In the absence of clear and convincing evidence, the issue of punitive damages should not have gone to the jury. As to the October 18th through October 20th false imprisonment claims, there was no evidence that the physicians involved in moving Maya to the EEG room had actual knowledge of the wrongfulness of the conduct, or that moving Maya into the room with a video monitoring was reckless or wanting in care. Further, like the claims for January 6th false imprisonment and battery, there was no evidence presented that JHACH participated in the actions or that the officers, directors, or managers of JHACH condoned or ratified the conduct. The trial court erred in submitting the punitive damages claims to the jury. And therefore, those punitive damages claims with respect to that false imprisonment claim are also vacated. H, fraudulent billing. The trial court denied JHACH's motion for directed verdict on Mr. Kowalski's claim that JHACH fraudulently billed the Kowalski's health insurance carrier by using a billing code for CRPS. To survive a directed verdict, Mr. Kowalski had to establish that JHACH made a false statement concerning a material fact in the bills to Mr. Kowalski and his insurance company, that JHACH knew the statement was false when it made it, that JHACH intended that Mr. Kowalski or his insurer would rely upon the false statement, and that Mr. Kowalski or his insurer was injured as a result of that reliance. JHACH contends that the trial court erred in denying its motion for a directed verdict, where Mr. Kowalski presented no evidence that JHACH made a false statement of material fact in billing Mr. Kowalski's insurance carrier under a code for CRPS, and he presented no evidence of damages. We agree. So they're going to throw that claim out as well for fraudulent billing. There's no dispute that Maya was admitted to JHACH having already been diagnosed with CRPS by another physician. The dispute concerns JHACH's billing of the Kowalski's insurer, where, according to Mr. Kowalski, the hospital did not believe that Maya had CRPS and did not treat Maya for CRPS. Evidence of JHACH's billing was introduced as was evidence of payments by the insurer. However, Mr. Kowalski presented no evidence that JHACH's bills included false statements. I tended to agree with this determination as well, and I remember voicing that opinion at the time, because I don't think that Mr. Kowalski paid any of the bills, and so there was really no standing to bring these claims, and that's what they say here. Further, Mr. Kowalski presented no evidence that he suffered pecuniary injury for the alleged fraudulent billing. He presented no evidence that he was billed for the treatment or that he paid anything. Moreover, in closing argument, counsel for Mr. Kowalski suggested that the jurors award $1 in nominal damages for this claim unless they found evidence of an increase in insurance costs or copays. Post-verdict, Mr. Kowalski agreed to remit the jury award to $2 because Mr. Kowalski requested damages only for deductibles or copays incurred and difficulty of finding insurance in the future in the operative complaint, and such damages were not proven. Where the claimant is unable to prove that he or she was injured from the alleged misrepresentation, the trial court must grant a directed verdict on the claim. Footnote 20. Despite the concession that no pecuniary damages for fraudulent billing were proven at trial, counsel for the Kowalskis suggests that the trial court correctly denied the motion for a directed verdict because the jury was entitled to consider Mr. Kowalski's loss of Mrs. Kowalski as billing fraud damages, and Mr. Kowalski's loss of Mrs. Kowalski would have reasonably supported a verdict of $5 million for billing fraud. No authority is cited for this argument, and we have found no basis in the law to support it. Right. So the jury awarded $5 million for fraudulent billing, but there really was no evidence of fraudulent billing. And just think about it this way. We're going to be fair to all sides. By allowing in this evidence of fraudulent billing, you're putting in the jurors' minds that the hospital is also committing fraud in addition to all of these other horrific things that are claimed that they did to Maya, and things that they did that caused Beata Kowalski to take her own life. And so you have to weigh the value of how prejudicial that is to the defendant to how probative it is to the plaintiff and the claim. And so that could be considered highly prejudicial. I don't think they're even going to get to that argument here because they get to it another way. But I'm just telling you another way that this could have been overturned, because in my opinion, that evidence never should have been allowed in at the trial because they didn't have any evidence of it. The fraudulent billing part. Here's section I, new trial. The complexities in this case are only more complicated by the existence of immunity pursuant to section 39. JHACH contends, as it did below, that the trial court's error in interpreting section 39 pervades not only the court's evidentiary rulings, but the trial itself, such that a new trial on all remaining counts is necessary. Footnote 21, which says, we do not address whether those claims survive on remand under a correct application of section 39 immunity or otherwise. We would exceed our function were we to give an opinion on the merits of any of the claims for which a new trial is required. It is incumbent upon the parties to present the case anew and for the trial court to rule on the evidence and issues arising therefrom and presented to it. As discussed herein, we agree. Moreover, the totality of all errors and improprieties, including those not discussed herein, was pervasive enough to raise doubts as to the overall fairness of the trial court proceedings. And here we all were watching this trial, and we thought that Judge Hunter Carroll was so fair and so just. And this appellate court says that there were so many errors and improprieties that it was so pervasive that the overall fairness of the entire trial court proceedings are at issue. And therefore, here's our conclusion. The final judgment in favor of the Kowalskis is reversed. On remand, only the intentional infliction of emotional distress claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. And that is it. Everything else, tossed out. He did. Jason Smith says he bent over backwards to make sure he didn't have appellate issues. There's nothing a trial judge hates more than being overturned on appeal. And this is overturning just about every decision that he made during the course of that trial. We know because I didn't watch it with you live every day, but I did try and watch as much as I could of it every day. And so the malpractice claims will go back for retrial. Some of the false imprisonment claims will go back for a retrial. Maya's intentional infliction of emotional distress claim and the battery claim. Everything else, tossed. Well, I guess this was only a 3-judge panel because it was one judge who wrote the opinion, and then Judge LaRose concurs, and Judge Smith concurs, and then there's another judge who concurs and writes separate concurring opinion, which I don't have time to read to you right now because it goes on for another 9 or so pages. And Jordy says, time to suit up for trial 2.0 then. FYI, everyone, Miss Scarlett is here, and she says, FYI, November is CRPS Awareness Month, represented by the color orange. Hang on, let me go to the beginning of that document. So there's a Judge Black who wrote the opinion, and then 2 more judges who concurred. One of them wrote a concurring opinion. Jason emailed all of his Maya memes to me. Let me see if I can find it for you. Wow. Remember the days of the Judge Maya memes? Oh, that's right. Hang on. Sometimes we have to laugh, otherwise we just cry all the time. Judge Hunter Carroll. Oh, yes. This will remind us of some of the things that we sat through during the trial, but I got to like open each one of these individually. It's like a whole thing. So just give me a minute while you talk amongst yourselves. I follow Maya Kowalski on Instagram. She looks really good lately. And this is heartbreaking. I don't know if she posted anything today with regard to this breaking news that so many of you sent to me. And so here are some memes courtesy of our friend Jason Smith in chat. Orange hearts in the chat for CRPS Awareness Month. So many of you also suffer from CRPS and came to me during this trial. Courtesy of Jason. This one says, bus stop people. Oh, there's Sally Smith. And there's a wanted poster in the back for Catherine, I think Kathy Beatty and Sally Smith. And here's one that says, ASMR Shapiro, Maya, so glad you made it. The Shopkins are just upstairs right this way. Oh, remember the Shopkins? What was it about the Shopkins? They wouldn't let Maya have Shopkins in the hospital. She wanted the Shopkins. I don't remember exactly the reference to that right this second. And there was this one that Jason made. And that was the judge, Hunter S. Carroll. And it says, I went and got the papers myself. Judge Hunter W. Carroll. Remember he went and got the documents himself? The IJ documents? They gave her some Shopkins. John Shopkins, yeah. Space Dudette says, I love how the big silver play button sparkles behind you. Oh, thanks. It's a milestone in my YouTube career. And I thank each and every one of you who has taken the time and energy to hit the subscribe button. It's free. You got me there. You guys are amazing. There's another one. And this one says, nope, nothing to do with Big Pharma, Yvette. Nothing to do with Big Pharma. This has to do with medical kidnapping and DCF, taking children away from their parents, and some Munchausen by proxy thrown in there too. Motion to strike. Introducing in his debut, Judge Hunter Carroll by Kowalski Pictures. And they tried to withhold documents. They tried to gaslight him. They even accused him of judicial misconduct. Judge Carroll will move to strike. Very creative, Jason. And the last one says, juror number 1. Join me, and together we ruin the name of every hospital in the galaxy. Your friend, Howard Hunter. Well done, Jason Smith. Everyone give Jason Smith props for doing that for us. I want to wait and see Peter Tragos's breakdown on this, because Peter Tragos is a civil litigator. He also is a Florida practicing attorney. He didn't cover this case for part of the time because of his, I don't know, maybe he knew the judge or he knew some of the attorneys in the case. And so he didn't cover it like full blown, but I'm sure he's going to cover this appellate decision, and he will let us know whether or not there's another avenue of appeal after this, because this is the District Court of Appeal of Florida's 2nd District. I don't know if Florida, if after this, if there's a Supreme Court level after this, and I don't want to give you any wrong information, and I don't want to take the time while we're sitting here to actually research it. But it sounds like they're sending it back for a new trial. So will it be assigned to a new judge? Will they continue with the case? Will there be a plaintiff's attorney who's continuing with the case? Rob of Law and Lumber covered it, as did Ian Runkle. That's right. You just outed yourself, Jason Smith. Okay, I was trying to keep your identity a secret, but Jason Smith is also Kazi G. Jason Smith is also the one who calls Into the Glare pretending to be Cosgrove, and you do a wicked good impression of Cosgrove. And so you just outed yourself. I wasn't going to do it. You did it. But again, appeals are really expensive. The printing costs alone for appeals are tens of thousands of dollars. Tens of thousands of dollars. Redheaded Princess says, lawyer, thought it would have been overturned in appeals. Yeah. I, for one, also thought that those intentional infliction of emotional distress claims were very tenuous. They're very, very hard to prove. I thought that they were going to have a very, very difficult time proving a causal connection between Beata's taking of her own life and the hospital's actions. And so I have to digest this a little bit more before I can give you my full-throated opinion on this, because this was a cold read for me. So many of you guys sent it in and you really wanted to go over it today. And I did another show before this. And so I have to get out all my red pens and put up the verdict sheet and all the damages and then what got overturned and what got reduced and see where we stand and how many claims are left to go back for a retrial. So Arizona DCS Oversight Group says, I do have some inside info about the next step, but doubt there will be another trial based on what I know. Well, here's the thing too, so many cases like this will settle during the pendency of the appeal because appeal is always risky to both sides. Mitchell says, Jason, congrats on coming out. Appeals are so risky to both sides. I'm wondering, were there settlement offers made while we're in the last 2 years waiting for this decision from the Second District Court of Appeals in Florida? And why didn't they settle? Was it not enough? Did they not offer enough? Jason says, Melanie, this is infuriating. If you remember, my meme made it into their motion for a new trial. Oh, yeah. I can't believe they're making them do it again. Thanks, Jason, for your super chat. Kevin from South Boston says, feeling cute. Just FOIA'd MSP, BPD, CPD, and Mass DOT. Awesome. From across the pond. They might send you a big bill, but let me know if they do. And if they do, oh, man, you can't make this up, Scott. That's crazy. I saw that earlier this morning, actually. All right, we'll go over that in a second. I'll leave it up so I remember. If they send you a big bill, let me know. Maybe I'll split it with you. Thanks for tuning in from across the pond. Auntie Candy is here and says, this is heartbreaking and also alarming in our healthcare system. Let's be honest. It's broken in so many ways. It is. And so many people didn't realize that the state could take your child away from you based on one woman, Sally Smith's opinion that you have Munchausen by proxy. And it was just sad in so many ways. And Julie says, I think it's Julie, Florida Supreme Court could disagree with the appeals court, right? I don't know the succession of the courts there, and if this is appealable to a higher court, if the Florida Supreme Court is above this court, I don't know. I could look into it and let you know. And so I don't know, but I will say appeals are very expensive. And again, plaintiffs' attorneys fund the cases. Do the Kowalskis have the money to be able to afford to pay the appellate costs? Is there another attorney out there who's going to fund it? Or will they just go retry it? Or will they try and reach some sort of settlement that everyone can agree with to just end it? It's been 2 years since the verdict, right? Sammy and Melissa, thank you both for becoming members. And Mike says, I give up. Let someone who's innocent go to jail for life. Protect a hospital. We need a new trial. Crazy, right? Stephanie, been here for 22 months, says, thanks, Mel. This ruling is ridiculous. I have to get out, I have to make a chart. I have to make a chart and figure out what claims still remain. And I have no idea what's going to happen next. It is always my advice, if you can get enough money on the table, settle the case. Because again, you don't want an appeals court deciding your family's financial future, right? We all knew that a verdict of $261 million was never going to stand on appeal. Everyone, every attorney who covered this case said the same thing. Back to the 80s says, do you want the stream of Kate Peters of today? It shows all of them, including Kate. It shows the lawyers also, plus the prosecutor. Well, if somebody sends it to me, I'll take a look at it, but we've already covered it. And so I don't see a reason to cover it again. But as always, you're always welcome to email me. My email is always in the show notes of the video. I do read them all. I just can't respond to them all because I get hundreds a day. Hundreds. I can't summarize for you at the end what is left because I don't know what is left. Well, I actually just told you what was left in the final paragraph of the decision. We just went over that, so maybe rewind just a little tiny bit. But I need to get out my charts and pens and dollar amounts and calculator. Anderson's off the case. So Anderson was fired by the Kowalskis, and Nick Whitney has been hired, and I think that he's the one who still has it. Frogman Phil said something up here that I thought was interesting, all in caps, so it's easy for me to find. Hang on. Flo Livin says, looks like Maura Healey has a problem. Lincoln Chatter, Google breaking news. Yeah, there's some breaking news about a cocaine scandal happening in Boston. And an aide to Massachusetts Governor Healey was charged in a cocaine trafficking scheme that was allegedly linked to the state building. Somebody sent me that this morning. Just, hard for me to cover everything in the same day, but it looks like that seems to be the case. Thanks, Flo Livin and Sarah Kelly. Thank you for becoming a new member. And then here in chat, somebody said, let me see if I can find it now. Frogman Phil said, Melanie, without too much information, Maya was my patient for months. Her parents and so much her mom was all in for her child with CRPS. I know. So many things about this are scary. Thank you, Frogman Phil, for being there for Maya and Beata. Arizona DCS Oversight Group says, unfortunately, medical kidnapping happens about every 9 minutes in this country. Bring an attorney along when you take your kids to a doctor and or hospital. Not kidding. Right. KBD says, think about all that went on before social media, YouTube, the internet, etc. We didn't know all this went on. It has gone unchecked and hidden from the public, basically. Yep. That's true. But in any event, it's going back for a new trial. So the entire jury verdict has been overturned by this appellate court. There is no money that is owed to the Kowalskis right now as we sit here today. And Bridget said, I wonder if the jurors are like, well, what did we find a verdict for? So there's that. Hang on. Wait, what is this, Kendra? Hold on. Where is Sally Smith now? Oops. She has since retired. She's been interviewed about her perspective on the case, including in the podcast, Nobody Should Believe Me. Her story was also featured in the Netflix documentary, Take Care of Maya. Okay, Nobody Should Believe Me. I guess there's a podcast to go find if you want to see what Sally Smith is up to now. All right, thoughts, questions, comments, concerns before we wrap this second stream of the day. I need to go rest my voice and drink like an entire bottle of Manuka honey to be ready for tomorrow. Tomorrow at 2 p.m., we have a hearing, status hearing in front of Judge Krupp on Miles King and Brian Walsh, etc. And I'm sure there will be something breaking in the morning to cover. Thank you all for being with me today for the majority of the day. We've been here for 2:15 now and a couple hours this morning, so it's been a very full day. Arizona DCS Oversight Group says one of the things we do is educate the public on this stuff. Most don't believe us. It's one of those until it happens to you type of situations. People just can't wrap their heads around it. Do you have a channel? Shoot me an email if you like. My email is in the show notes below. It's going back to the trial court. That's where it's going. And thank you for all of you who are sending me these emails with these new articles, but I just don't have the voice left in me to talk anymore today. I need to go see what shit they're stirring up about me over on the cesspool of Twitter. And people have also sent that to me. So we'll see. We'll see. Thank you to the moderators. It's been a full day for them. They are the greatest at what they do. And you know that. And so thank you to all the moderators and for being with me today. And for all of you for taking interest in the Maya Kowalski case. Go back and watch my playlist. Go back to the verdict day. Wait, hold on a second. Maybe we can just play that portion of it. Let's see. Remember when they read the verdict? It was so emotional. I can't find the part of it right now. Maybe we'll watch it another day together. It was a lot. This case was a lot. But it's where our outrage began, Kazi G, right? And then we parlayed on over to the Karen Reed case where our outrage continues. And now we're continuing the outrage with Kelsey Fitzsimmons and with Aaron Spencer and with that football coach's son in Oklahoma who got a smack on the wrist for almost killing a girl and raping 2 different other 17-year-old girls. It's horrific. All right. Stay cool, stay kind, stay classy, stay out of the fray, stay above it all. I know you can do it. I know you can. The thing that I also would ask you to do, first of all, let's read somebody, is also make sure you have all of your notifications set. Make sure that you are subscribed, because YouTube has been unsubscribing people lately for some unknown reason that I can't fix. And so if it did happen to you that you're blocked, send me an email with the actual link to your channel in it, and I will correct it if indeed that is what happened to you. I apologize. And therefore, as such, I fix it for you. But let's see if we can redirect on over to somebody who's going to be live or going to be live. I want to see if either Peter or Runkle. Oh, I'm gonna teleport you over to Runkle, because I'm gonna trust that Runkle has read the entire decision, unlike I did not have the opportunity to do. It's going to be at 8:30 p.m. tonight, so you have some time. I'm going to teleport you over to Runkle because I love Runkle, and hopefully he has a chance to digest it, and he'll be able to give you more insight than I was able to give you today. And so when I end the stream, it will teleport you over there. Tell him I said hello. Tell him that we love him. And Lady Zelda's doing a Kelsey fundraiser. Go over there too. Thank you so much. I appreciate you. And thank you, Frogman Phil, who says, Melanie, I watch you during a lot of days. You're great. As I watch you while as a retired U.S. Navy DMTRN, you're adorable. Thank you so much. I type in caps because I refuse to what? Follow the rules? Thank you. I'll take the adorable compliment. I appreciate you. And Dawnberg says this is crazy. All right, get on over there. Go to Lady Zelda too. First, hit the reminder to go back to Runkle in an hour. I don't know what time Lady Zelda's on because it didn't come up in my possibilities for redirection. And I do as much as I can. And I try and do it all for you. And you guys are amazing. And I love you with all my heart. Thank you, Yvette. I love you too. And I'll see you guys tomorrow. Stay cool, stay kind, stay classy. Say hi to Runkle for me. And yes, I'm sending you there now. Buckle your seatbelts. Head on over for teleportation. Prepare to teleport. And I'll see you tomorrow at 2 o'clock at the very latest for the Walsh Miles King hearing. Probably in the morning on something else. Peace. Good night, everybody.